Welcome to our continuing 2017 educational webinar series. I am Catherine Short, Partnership Marketing Specialist for First Healthcare Compliance. At First Healthcare Compliance, we help you with a comprehensive compliance management solution tailored to your business, a hospital network, healthcare practice of any size, billing company, or skilled nursing facility. As part of our complimentary educational webinar series, we bring you experts from around the country to discuss relevant topics in the healthcare industry. Today, we are so pleased to have Nathan Fish and Summer Hayes, associates at Greenberg Traurig in Dallas, Texas, as presenters for our webinar for First Healthcare Compliance. Nathan counsels healthcare clients on a wide range of regulatory issues, including fraud and abuse, marketing, Medicare, Medicaid enrollment, and reimbursement and licensure. Nathan also has wide-ranging experience with healthcare transactions, internal investigations, and compliance reviews, and government enforcement actions, investigations, and audits. Nathan concentrates his practice on the following areas: healthcare compliance programs, transactional due diligence, healthcare regulatory matters, and healthcare industry acquisitions. Summer Hayes represents healthcare providers in all manners of regulatory, transactional, administrative, and litigation matters, including advising clients regarding federal fraud and abuse laws, such as Stark and anti-kickback statutes, advising clients responding to investigations, and advising clients regarding establishing and maintaining compliance programs. Prior to entering private practice, Summer was a registered nurse in various hospital and outpatient settings. She has broad experience with both the clinical elements of the healthcare industry as well as practical business elements of providing those clinical services in a highly regulated environment. A copy of the slide deck is available for download on the control panel. Feel free to submit questions into the question box on your control panel during the presentation. We will address questions at the conclusion of the presentation. Your Paycom CEU certificate will be emailed to you from Paycom following the broadcast. There is no need to request it. Additional CEU opportunities will be available to BC Advantage members following the live broadcast. See their website for details. Nathan, Summer, go ahead.
All right, well, thank you so much for having us today, and going to kind of talk through the lay of the land these days and the enforcement of federal and state healthcare laws. We understand that you guys have a varied background, and so we're going to try to strike a middle ground with sort of going over the basics of the statutes and some of the players, and then leave some time at the end to talk about case law and some of the recent enforcement actions that have sort of changed the landscape in some ways for those of us in the provider space, and then also wrap up with some questions if you guys have any questions for Nathan and myself. Kind of just to start out, we're going to kind of walk through the players just to make sure everyone is on the same page as far as those persons involved in enforcing the various healthcare laws on both the federal and state level. We, have the Department of Justice. It kind of comes in at the top, and we have all the local district attorney's offices. You're probably very familiar with the Office of the Inspector General, the Medicaid Fraud Control Units, and the Centers for Medicare and Medicaid Services. Various Medicaid state agencies are involved. There is a TRICARE Management Authority that you may hear about from time to time in enforcement actions, federal and state contractors, licensing boards. A lot of the focus has been on whistleblowers and some of the cases that have come to light based on their inside knowledge into the different providers and suppliers. And then I think the one we kind of want to start out focusing on, just due to some recent happenings, are the commercial special investigative units. So Nathan, you want to kind of bring us up to speed there?
Sure. Recently, in the last few years, SIUs, as they're called, have become pretty active, and PBMs have them, and then other commercial insurers will have them internally. And what these units do is, that it varies, but frequently what they'll do is audit claims or audit supporting documentation, or even audit ownership of, for example, pharmacies. And they have the ability within their private insurer entity to suspend payments, to trigger recoupment, and they can be very disruptive. And the unfortunate part is there's very limited appeal rights. There's typically an internal appeal that the payer will allow, but really that's the payer just rubber stamping what their SIU's already determined. So it's very difficult to overcome an adverse determination by an SIU if one ever does occur. And I just further note that licensing boards they appear to be getting a little more active with enforcing fraud and abuse. I mean, it's not every day, but you do see some activity in Texas and Oklahoma, for example, in the last couple of years, where boards that had previously not wanted to touch fraud and abuse related issues are suddenly willing to discipline physicians, for example, and pharmacy owners for practices that potentially run afoul of fraud and abuse laws.
Okay. We're going to kind of walk through now some of the big statutes. I think starting with one that we're all familiar with, but kind of going into a little bit more detail, the anti-kickback statute. Oh,
okay, yes. So you may all be very familiar with this, so I'll try not to bore you, but basically the anti-kickback statute, this is a federal criminal statute, it makes it a felony to pay remuneration to another individual or entity in return for that individual or entity referring a federal healthcare program beneficiary or purchasing an item that's reimbursed by a federal healthcare program. The bottom line is this is a very broad criminal statute, and it's been interpreted broadly by courts and by OIG. Courts have adopted the one-purpose test, which holds that if even one purpose is to induce referrals, then a payment's illegal, notwithstanding any legitimate business purpose that may have been involved in the arrangement. The interpretation of remuneration is also very broad. It includes anything of value, so it's not just cash bribes. It can include even providing another provider or supplier with the ability to bill for services they previously had not been able to bill for. So pretty much anything of value that's flowing between referral sources would be considered remuneration. Similarly, the idea of a referral is very broad and in fact includes marketing. So the OIG has said that marketing staff are involved in recommending or arranging for the purchase of federal items and services, and therefore when they generate business for a provider or supplier, they are technically making referrals that are covered by the anti-kickback statute to that provider or supplier. As previously stated, it does include non-clinicians. There's a misconception that you sometimes run across where folks believe that the anti-kickback statute only applies to providers or suppliers, but that in fact is not the case. And as stated before, even consultants and marketers are considered to be covered by the statute. The statute does form the basis for civil liability, potentially, if there's a violation under the False Claims Act. And violation is a felony. It is punishable by substantial fines, up to 5 years imprisonment, CMPs, and even exclusion. Penalties apply to both sides of the arrangement, and there are state analogs that mirror the federal anti-kickback statute or sometimes deviate completely from it, but most states have adopted state kickback provisions that are either similar to or are identical to the federal anti-kickback statute. Oftentimes they are broader, though. and we'll discuss that a bit more in a few minutes. There are a number of exceptions and safe harbors to the anti-kickback statute. If an arrangement falls within one of these exceptions or safe harbors, it is immunized from liability under the anti-kickback statute. Examples of well-known and frequently used safe harbors are the Personal Services and Management Contract Safe Harbor. This is really the only safe harbor that protects payments made to independent contractors. Bona fide employee safe harbor. This is a very broad safe harbor, and it's somewhat different than the Stark law safe exception that we'll discuss later, in that it's broader than Stark. It only requires that an employee be a bona fide employee in order for any payments to that individual to be within the regulatory safe harbor. There is an investment interest safe harbor. This generally protects investments in small investment interests as long as various requirements are met, and notably the two restrictions are that referral sources can only own 40% interests in the entity, and they can only generate 40% of the business. Frequently used by hospitals are space and equipment rental safe harbors and a discount safe harbor, which protects discounts and rebates. I'll note briefly, to the extent that any of the participants are hospital compliance officers, the discount safe harbor is somewhat in a state of uncertainty, and there's some ongoing litigation that may help us better understand what exactly the scope of the discount safe harbor is. But generally, for all of these, except the discount safe harbor, it's fairly broad, but for the others, you're going to need commercial reasonableness and fair market value in order to meet the safe harbor requirements. Commercial reasonableness is somewhat of a fuzzy concept, but basically it means that legitimate services are being provided and that the recipient actually needs them. An example of arrangements that are not commercially reasonable would be a single company having 25 medical director agreements, a small company having 25 medical director agreements, where clearly the responsibilities are duplicative. Those would not be considered commercially reasonable and would likely not only not be protected by a safe harbor, but would be problematic under the kickback statute. Fair market value generally, ideally I should say, you would have obtained an independent third-party valuation to support any compensation that's flowing between the parties. That's not always possible, and so there are other ways to mitigate or to mitigate risk and to help ensure that your payments are within that fair market value range. Safe harbors are voluntary, so if one does not apply, it does not mean a violation of the anti-kickback statute has occurred. Instead, what the OIG does is, what's necessary is an analysis of the totality of the facts and circumstances. And OIG has identified a number of factors that it looks at when it's conducting this type of an analysis. Clearly, the most important factors that it focuses on are overutilization and increased federal health care program costs. They're typically linked, however, they don't always have to be. They are also have voiced concern for interference with clinical decision-making, patient safety, freedom of choice, and unfair competition. With regard to overutilization, the concern is that payments to a referral source will induce that person to refer more cases there than they should, and that can lead to patient harm and also increased program costs. If you are outside a safe harbor, but you can make an arrangement meet as many of the material requirements of a safe harbor as possible, it's generally considered to lower the risk. An example is percentage-based compensation. Generally speaking, percentage-based compensation is not protected by the Personal Services Management Contract Safe Harbor. So, for example, many management contracts for physician practices are based on the compensation to the manager is based on percentage of revenue. Those are not protected by a safe harbor, but there are other ways to, other requirements for that safe harbor that if you can structure the arrangement to meet will help reduce risk generally. Summer, are you going to talk about the Stark Law?
Yeah, absolutely. Stark Law is one that, sort of puts you a little bit more on edge because Stark Law is strict liability. They don't look at the totality of the circumstances if you don't meet one of the exceptions. If you don't meet one of the exceptions, then you violate the Stark Law. The limiting factor with Stark Law, as you may be aware, is that it must involve a relationship with the physician who makes referrals to the other party to the transaction. And those referrals are sort of somewhat limited to designated health services, DHS, as it's often referred to. So we're talking about things like inpatient and outpatient hospital services, labs, imaging, DME. The list goes on, but that's just sort of a brief overview of designated health services. So any relationship between a provider or supplier of designated health services and a physician needs to be structured to comply with one of the Stark Law exceptions. Often you see real estate leases, hospital owns an office building and leases the space to a physician. You see arrangements between physicians and labs. I'm trying to think of some other examples. Medical director agreements between an imaging center or a lab and a physician or a hospital and a physician. Even physician independent contractor arrangements with a provider or supplier of designated health services would need to be structured to fit within one of the Stark exceptions. In some cases, I think the Stark exceptions, can be a little bit more giving than the anti-kickback safe harbor. But I mean, that's a good thing because we have to hit the Stark exceptions, whereas with the anti-kickback safe harbor that Nathan discussed, we have a little bit more leeway, to get as close as we can or to otherwise structure the arrangement to minimize risks. Some of the popular Stark exceptions, there's obviously one for publicly traded securities. This is your companies that are traded on the stock exchange and that kind of thing. Bona fide employment relationships, as we talked about, where physicians are actual employees and they have fair market value compensation among other requirements for the exception. Personal services arrangements, that's going to cover your some of your medical director agreements and any personal services that are provided. Rental of office space and equipment. Again, I think that most often comes into play where a hospital owns some piece of real estate that the physician practice is going to lease or occupy. Fair market value, similar to what Nathan was discussing. Ideally, especially when we're talking about Stark and strict liability, you want to feel comfortable that any compensation being paid is fair market value, and really the best way to document that, and some would argue the only definite way to document that is to have somebody do an appraisal and to document fair market value for the given relationship. That's not always possible, and that's one of those ways you can try to mitigate your risk as much as possible, but you have a little less leeway in the Stark Law arena than you do under the kickback. And there's also indirect compensation arrangements, which is where you have a third party involved. You've got a physician-owned entity or a hospital-owned entity that has a relationship with the physician. And there's other examples. That's not all-inclusive, but that's sort of at the top of the list. And so you're never going to have a direct arrangement between the provider of DHS and the doc, but you are going to have an indirect relationship always. There is an unbroken series of links between the physician and the provider or supplier of designated health services. And those arrangements actually are unique and sort of in a class by themselves. There's actually, where you have indirect compensation arrangements, there's a specific exception there. I think that's something that's often can be confusing in the Stark arena is when you have an indirect arrangement, your rest of your exceptions sort of fall to the side, and you're looking at the indirect compensation exception to the Stark law. I think that's probably a good takeaway to about the Stark law to keep in mind, and that you must meet every requirement of a Stark exception. It's not get as close as you can, or hey, there's an OIG advisory opinion favorably weighing in on this from a kickback perspective. Okay, well, that doesn't cover us from a Stark perspective. So you have to meet every prong of the Stark exception. And again, commercial reasonableness and fair market value are key here as well. Think of anything else on Stark, Nathan?
It's a civil penalty. You may have discussed this, but it's unlike the anti-kickback statute, which provides for criminal penalties. The Stark statute is civil liability, and essentially the penalty is that you may not submit claims, or the prohibition is that you may not submit claims for reimbursement. So the effect of making a prohibited referral is that the parties have received an overpayment, but there's no criminal liability. And I think that's a significant difference between the anti-kickback statute and Stark, even though they often overlap.
Yeah, and remedies including exclusion as well. So there is that element being excluded from participation in Medicare and Medicaid.
Moving on from Stark, just briefly here, the civil monetary penalties law is another OIG remedy, administrative remedy. And I think I'm just going to focus on the beneficiary inducement component of it briefly. And basically what this statute says is that you cannot provide something of value to a Medicare Medicaid beneficiary to induce them to select you or another as their provider or supplier of services. And there is this most often comes up in the context of co-payment waivers, but you'll also run into it with some of these drug cards and whatnot. There's a nominal value exception. I believe it's $15 for each individual gift. It's $75 in the aggregate per year. The threshold recently was raised by OIG, but it does allow for some gifts or items of value to be given to beneficiaries for free. But the bottom line with the CMP law is that it's not governed by the rules of civil procedure or evidence, so it's perhaps a little bit easier for OIG to enforce than having to go through with the full kickback violation. It also deals with kickbacks as well. So, something you want to talk about the False Claims Act?
I think most of us are fairly familiar with False Claims Act generally and false and fraudulent claims, but I think I wanted to sort of highlight what is known as the Reverse False Claims Act, which I think is particularly relevant from a compliance perspective. I have seen this come up in several different contexts. One can be simply having a credit balance on your on your books that Medicare's overpaid in some way, and just figuring it'll even out eventually as payments come in, and that is an overpayment, and it by law has to be refunded within 60 days of the identification of the overpayment. But I think more often, I guess where we come from and where I think compliance probably runs into this is where you have, let's say you discover that you have incorrectly billed for something. I mean, you have been coding for something that should have been included in another procedure code or billed by a different person in the supplier or provider network. You not only have to identify that, and you got to return the money. And there's some ways to buy yourself some more time, but the Reverse False Claims Act officially says when you identify that problem and that overpayment, you have to go ahead and return that money, or else it becomes a reverse false claim. So I think that's something that was part of the Affordable Care Act. So that's still somewhat new, and there's been some clarifying guidance that's been issued over the last couple of years. So just something to point out as we talk about the enforcement environment currently.
So states have their own set of fraud and abuse laws that apply. So you have to consider more than just the federal statutes, and these vary from state to state. So, for example, most states have anti-kickback statutes. They range from Medicaid only, which essentially does nothing to expand the reach of the federal statute. Some apply to commercial payers, some apply to all payers, including cash-paying patients. So you get, in many states, a broader kickback prohibition under state law than you do under federal, because remember, the federal anti-kickback statute only applies if it involves items or services that are reimbursed by Medicare, Medicaid, TRICARE, and other federal health care program. These state kickback prohibitions appear in a variety of places, from physician licensure statutes or other professional licensures statutes and regulations to insurance codes, and so it can be somewhat difficult, and frequently there are overlapping provisions in a particular state, so it can be somewhat difficult to interpret how these different state kickback prohibitions in a particular state interact with one another. Some have safe harbors, some don't mention safe harbors at all, and so it can be difficult to determine the scope of the prohibition generally, because if they're mirroring the federal anti-kickback statute, the language is so broad that it would cover many, many arrangements that, even in the healthcare context, would be considered legal and under the federal anti-kickback statute. So I guess this kind of ties in with the final comment I'll make. These statutes are enforced inconsistently, I'll say. In some states, the kickback prohibitions are rarely enforced, and other states are quite active. So it's special care has to be taken when trying to determine how much risk is exactly involved under state kickback prohibitions. Generally speaking, I think attorneys take the position that if an arrangement is permitted under the federal anti-kickback statute, and let's say it's an arrangement that fits within a federal safe harbor, clearly, that there's little risk under applicable state law, but that analysis needs to be conducted on a case-by-case basis. States also have mini-Stark laws, which are similar to the federal Stark prohibition, but they can be broader or narrower as well, and they can include commercial payers. They can include items and services that are outside the definition of designated health services. Some of these mini-Stark laws merely require disclosure of the physician's arrangement or interest in the entity that he or she is referring to. So those warrant consideration. Additionally, some of those self-referral prohibitions are baked into the licensure statutes, so you have to be careful that a state board doesn't come and start asking questions about a prohibited arrangement. Additionally, workers' comp, commercial bribery, consumer protection, and false claims laws need to be considered under state law.
All right. You may have heard about sort of a change in tides in the enforcement of the Anti-Kickback statute, and that involved some recent Federal Travel Act enforcement actions where they used a federal statute. It's here on the slide, the Anti-Racketeering statute, to basically work their way in and enforce some particular state laws. In a recent case in Texas, they were commercial bribery state laws. So it has sort of changed the landscape in some ways for those providers that typically function outside of the government payer context. We don't take Medicare and Medicaid, so we're outside of the realm. So that it just has sort of been, everyone's still trying to wrap their head around exactly what all this means, and changes that are coming down the road as a result of this. But the Forest Park case was a physician-owned out-of-network hospital, and the government looked really closely at communications that were involved. Basically the hospital was paying a lot of money to docs, and under the agreements with the physicians, they had the boilerplate language that said this payment is not intended to compensate you for referrals and that kind of thing. But they looked outside of those contracts, and they looked at emails that had been sent that basically said your projections have fallen, short of what we originally anticipated. And they looked at communications that were sent along with checks that basically showed a list of referrals that had been sent, that kind of thing. They looked really closely at communications, and I think that's definitely a takeaway, is to guard those communications. They're not, they can really come back to cause problems. But they also, despite the fact that this hospital didn't take any government payers, they ended up with significant claims paid because of federal payers that slipped through the cracks. And I kind of want to give some examples of how this happened, because I hear it time and again, and I'm sure Nathan does as well, from clients, we don't take any government payers, so we are not worried about that. They basically, these people can come in with United, Aetna, Cigna insurance cards, because those commercial insurance companies also serve as third-party administrators for various government entities. A third-party administrator is not actually the insurance provider, but they, send out the bills and they handle the paperwork for some of the school districts, school district employees, cities, municipalities, that kind of thing. And some of those can give rise to government payer-like claims under the anti-kickback statute. And so you think you're not taking government payers, but that United and Aetna card that you just took, is linked to a government employer. They also, the Federal Employee Compensation Act is a federally funded health care program for civilian employees of the U.S. government. That was one that had snuck through the cracks in a couple of places at Forest Park. Obviously, there's TRICARE, and there's other federal employee health benefits program, the Federal Employee Health Benefits Program for federal employees and their families. The Federal Employees Health Benefits Program contracts with a lot of different insurance plans to pay claims on their behalf, in the third-party administrator context. So they're not easily recognized as government payers. They don't have a Medicare card. They don't have a TRICARE card. So I think that's something to definitely take from Forest Park. In the end, Forest Park agreed to pay $475,000 to settle kickback allegations related to TRICARE and the Federal Employee Compensation Act referrals. There's also been a number of indictments of the different physicians that were involved, and those are at various stages in enforcement. I mean, it'd be impossible, I think, in this call for us to go over all of those. But Forest Park is just one. I mean, it's not a one-off case. There are other examples where the Travel Act has been used to enforce healthcare fraud and abuse laws.
Yeah, recently the biodiagnostic laboratory services enforcement actions have really resulted in significant convictions. I mean, more than 50 convictions and 36 physicians from one scheme operated by a lab. And the bottom line is there were sham arrangements whereby the lab was funneling money to these physicians to order blood tests, blood panels from the lab. And it has resulted in a number of the lab itself, and then a number of physicians pleading guilty to conspiracy and then violations under the Travel Act. Recently there was a physician, a 79-year-old physician, was sentenced to over 3 years in prison as a result of his role in this scheme. So it's been this enforcement has been cited as one of the larger Travel Act enforcement examples that exist. Similarly, there's the Pacific Hospital case in California involving a hospital that paid millions of dollars to physicians and others for referrals, including something $10,000 per surgery that was referred, and other $15,000 for lumbar fusion and $10,000 for cervical fusion surgery. So I mean, it was a lot of money. I believe in one case the physician received a total of $2.1 million. There were sham arrangements that allowed this money to flow between the parties, as well as the hospital had other entities, a management company that set up many pharmacies in physician offices that allowed the physicians to bill for pharmaceuticals. So it was a very broad and wide-ranging business that was ultimately the subject of the enforcement, and it has resulted in a number of convictions. The former CFO, an orthopedic surgeon, a chiropractor have all pled guilty, in part because of Travel Act violations. So again, as Summer was saying, this is not an outlier. You know, there are a series of cases, and the government will use the Travel Act when perhaps they don't have a sufficient leverage because of minimal federal healthcare program business. They will use the Travel Act to try to charge individuals and entities under federal law using state law kickback violations. So really getting into the private enforcement aspect of this presentation, there are a number of ways that private enforcement occurs, and that is private enforcement of fraud and abuse laws. Obviously, the best example are key TAMs, which is a whistleblower suit filed under the False Claims Act. I'm sure you're all familiar with them. Other examples include providers and suppliers using state law or illegality, not necessarily under state law, but using illegality generally to defend in breach of contract suits. So the example here is from 20 years ago, but a DME supplier hired a marketer and didn't want to pay him. And when the marketer sued for breach of contract, the DME supplier said, you know, we can't make this payment because it would be illegal to do so. And ultimately, a Florida appeals court agreed, and so they got out of that contract simply based on a percentage-based marketing arrangement. There's a growing trend of commercial payers suing providers to recoup payments that they allege were the result of resulted from a referral that was a violation of a state kickback prohibition, or in some way an out-of-network arrangement. And when I discuss out-of-network, for those who aren't familiar, basically what I'm referring to is a provider or supplier that's not within a private payer's network, but who, you know, where the private payer's plan requires them to cover out-of-network services. Typically, these services are reimbursed at a much higher rate. But with that comes significant cost-sharing obligations on the part of the patient, which in the subsequent cases we're going to discuss, the patient responsibility aspect becomes a part of the basis for the suit. So, for example, there's a couple of Aetna suits here. The first is against a network of ambulatory surgical centers in California, and Aetna claimed, alleged a variety of state law violations and causes of action. But the bottom line was it was an out-of-network billing and kickback scheme where a business that was out-of-network allegedly wanted to get higher reimbursement as an out-of-network provider but couldn't get patients in. So they allegedly paid physicians and waived patient co-payments in order to induce referrals and then to get patients to come in and actually receive the services from an out-of-network provider. Otherwise, they'd have to pay a substantial out-of-pocket cost. So in this case, a California jury awarded tens of millions of dollars in damages to Aetna based on state law, anti-kickback violations, and also fraud, insurance fraud type of claims. The basic idea there is that when you're submitting claims with exaggerated costs or charges to payers, even as an out-of-network provider, it violates some state prohibition on submitting fraudulent claims to payers. A pretty large, or at least it received a lot of publicity, large case in Texas was Aetna versus Humble Surgical Hospital. This was a small 5-bedroom hospital outside of Houston, and it was out of network. It entered into multiple arrangements with physician-owned shell companies, and paid them a portion of the facility fees that Humble received for services referred by the physician owner. And ostensibly, it was under some sort of a billing services arrangement, but in reality, Humble's staff were the ones who were performing the billing services. Ultimately, in this case, Aetna was awarded $41.4 million, which essentially bankrupted Humble. And it's worth noting Humble had prevailed in a similar lawsuit brought by Cigna, but the court here in the Southern District of Texas did not appear too impressed with the way that Humble had responded to some of the discovery requests, and it had conducted itself during the litigation, so that may have been a factor in this case. You all may know that about some of the class actions that are ongoing regarding beneficiaries suing commercial payers, but the bottom line is that the patients are suing commercial payers for charging exorbitant copay costs and other practices. Mission toxicology is another out-of-network case. Here you have it's an in-network case. You have a hospital that is an in-network hospital with reimbursement that's based on a percentage of the hospital's charges, which is different than normal hospital reimbursement, which is based on a DRG, and that's because it was a small rural hospital. And suddenly it starts submitting in February of 2016, it starts submitting claims, and by May 2017, it had submitted an astronomical $30 million worth of claims, and then had been reimbursed $9.8 million, all for laboratory services. And when Blue Cross's suit alleges that what the hospital was doing was allowing a couple of Texas laboratories to submit claims using the hospital's name and billing number for lab services that are performed in Texas and not at the hospital. And this is an ongoing suit, so it's hard to tell how it's going to turn out, but this is a good example of how, in contrast to out-of-network arrangements where providers are trying to overcome some of the financial barriers to providing services. In this case, the laboratory wanted to gain access to private reimbursement by using a hospital's provider number. And Blue Cross has objected primarily due to the sheer volume of the claims that were submitted. And these laboratory arrangements are pretty prolific, so some of you may be familiar with it. I think I'll skip the Ask Gary portion. Cigna has also sued. Again, this was fee forgiveness, so patients were not required to pay their cost-sharing obligations. I believe this was or toxicology screening. I could be wrong, but again, it's an out-of-network lab situation, very similar to the previous Aetna cases we discussed. Another United versus Sky toxicology. I think that you all are getting the point here that the key is that arrangements that feel questionable or that are, where, for example, you are taking advantage of out-of-network higher reimbursement, and that is the business model, is to bill out-of-network as much as possible, can run afoul and can get you into trouble with private payers. I suppose, arguably, some of these arrangements could get you into trouble under the Travel Act of the federal government, but I don't know that that's been tested. And I think that overall, what we're looking at here is greater involvement by the federal government in enforcing federal law based on state law violations, and more involvement of private payers in taking the law into their own hands, whether it's litigation or whether it's approaching the federal government and exposing arrangements that are questionable. And believe me, private payers know they receive information from competitors on a regular basis as to what the bad actors in a particular network are doing. So they know what arrangements, what questionable arrangements are in their network and what they look like in the details. And they may use that information to approach state licensure boards, the federal government, state attorneys general, and lobby them to initiate enforcement action. But the key is that no longer do you have to only worry about the federal government, DOJ and OIG sniffing around. There is a real risk of private payer action and of violations being cited that are based on private payer claims. So if anybody would like to ask any questions, we'd be happy to answer them. We're done with the primary portion of this presentation.
Okay, this is Catherine. We did have a few questions. The first one we had was similar to something that was brought up, I think, by Summer. So this question said, we screen out all government patients. Doesn't that mean we are safe as far as Stark and anti-kickback statutes are concerned?
Well, and I think that the easy answer to that is possibly. If you truly are screening them all out, then yes, but in reality, that's hard to do. Like we said, they're disguised as your Cigna and Aetna card holders when they come in, and it's almost impossible to know.
And it's not, the OIG has said that carve-out arrangements can violate the federal anti-kickback statute. And I guess the simple way of putting it is, if there are any federal referrals between two parties, and the parties establish an arrangement that only covers commercial patients, it could still implicate the federal anti-kickback statute. The idea being that the parties might use that private payer arrangement to funnel money that is actually a payment for referrals of federal business. So I think in looking at it from a kickback perspective, you'd want to consider whether or not an arrangement has, or the parties to an arrangement have any federal referrals between them, and then you would need to consider liability under the kickback statute and take steps to mitigate risk. The Stark law is a little different than the anti-kickback statute, and as a general rule, carving out is not as controversial. But under the anti-kickback statute, it can be much more controversial.
Right, I think that kind of goes to the whole, they're going to look at the totality of the circumstances. I mean, if you have a contract in front of you between two parties that, carves out all the federal payers, but then there's another side arrangement, where those federal patients are flowing between two related entities or, indirectly through a third-party entity to one of the parties to the agreement. I mean, they look at the whole situation, so there's unfortunately not just an easy yes or no answer to that. But I think, yeah, you're right. I did point out some of those other categories that can fall under the government beneficiaries that we sometimes don't think about.
And it's worth noting that carving out doesn't work when the allegation is a violation of a state anti-kickback statute or other state fraud and abuse prohibition or insurance fraud prohibition. So carve-outs are losing their luster, and for a long time they were considered to be, by some, to be a way around potential liability, and it's obvious now that that is no longer the case.
And just further to that, you know, many of the state equivalents of the anti-kickback and Stark apply regardless of the payer source. So, I mean, they don't, you know, carving out federal or state payers has, you know, has no bearing on any enforcement under the state statutes. And also, like we talked about, I mean, the federal government getting, through the Travel Act, finding a way to enforce state law claims for commercial bribery or that kind of thing. If you're paying someone, you know, for referrals, that could be bribery under state law, and the federal government has, you know, like we said, been enforcing that. So I just, overall, that's sort of, I think, the general theme is that carving out just doesn't get you where you might have once thought it got you from a risk mitigation perspective.
Okay, very good, very good. Doesn't sound very cut and dry then. Sounds much more nuanced then. Okay, so the second question that we had come in was, what can we do to minimize our risk in this enforcement environment?
Well, I think that really the key, there's two components to it. The first is to prospectively structure arrangements so that they minimize risk under any applicable fraud and abuse statute, whether it's federal or state. The most significant ones, and traditionally the ones that are considered the most, are the federal anti-kickback statute and the federal Stark law. Properly structuring an arrangement is essential to controlling risk, but equally important, and you know, that's, I'm sure that everyone on this call knows this, equally important is the ongoing compliance function. Many enforcement actions involve arrangements that may have been perfectly legal or at least low risk when they were initiated, and then over time the relationship evolves and practices change, and suddenly when the government starts to look into things, the arrangement looks much different. Physicians are being paid off contract. All sorts of benefits are being given to referral sources that weren't contemplated by the original arrangement, and it's sort of a creature of time and inertia. But so I think structuring an arrangement appropriately is not enough. You have to have a compliance function that takes into account ongoing review and monitoring of arrangements to ensure that they stay compliant. Summer, did you have anything to add?
I don't think so. I mean, just the recurring theme that, you know, your compliance program really has to be in effect and a part of the culture, and, you know, ingrained in the everyday, as you look at not just a piece of paper and not just an agreement that might come before, you know, come in front of you as a compliance professional, but from a broader perspective, overall, you know, a series of agreements, a series of arrangements, things that are coming to you that may be outside of an agreement, and kind of trying to put together the whole piece of the puzzle, because that's what the government's doing.
Any more questions?
I think that's about all the time that we have for questions right now. So thank you so much, Nathan and Summer. So thank you to Nathan and Summer, Nathan Fish and Summer Hayes from Greenberg and Traurig. We have their contact information here on the screen. There's Summer's contact information, and then we have Nathan's contact information there as well. So you can use their contact information on the screen for any questions. And if you have questions as well, we can forward them on. You can register for any future webinars or request a demo for our compliance solution on our website at firsthcc.com or call us at 888-543-4778. And thank you so much for joining us.